Hello, everybody. Welcome to Thursday. Don't know about you, anyone watching this, but it's been a frantic old week in this part of the world. So this is actually a nice moment to take a breather and do a webinar. I'm Chris Hines, Strata Advisor, Hines Legal, former Commissioner for Body Corporate Community Management. With me, as always, Frank Higginson, Partner, Hines Legal. Frank.
Hello. I'm just thinking, mate, I suppose I've been a partner at Hines Legal for nearly 20 years now. I suppose you're always going to be a former commissioner, aren't you?
But you're going to be a partner.
Oh, maybe not. Go to a special counsel at some stage is the traditional step down for partners. But anyway, not here to talk about our roles, are we? We're talking about?
Nice segue, Frank.
That was not prepared in any way, shape or form.
No, I've been trying a bit of role-related humour on the social media over the past couple of days. Even got a Limp Bizkit. I don't know if you've seen it. Even got a Limp Bizkit reference in there.
Okay, that's 90s music at its finest, isn't it?
Absolutely. Anyway, enough piffle. Today we're talking part of our series about the forthcoming new regulation modules, which start, 2.5 weeks. Where did the time go?
No idea.
New regulation modules starting 2.5 weeks, and our series and focusing on little bits of those prior to that. Today we're going to talk about the body corporate role, and I hear everybody give a collective groan of unexcitement about that. What's the big deal about a body corporate role? Well, that actually is a big deal, isn't it, Frank? It can be a very big deal.
It is, and I suppose this one, in a sense, is a bit of amalgamation of new laws, or new regulations, I should say, to talk about some of the tweaks that have happened to this, but also as a bit of a refresher for everyone in terms of the role. Because if we're going to have, well, I suppose let's start with this. If we're going to have an issue with someone in our community title scheme, the starting point usually is the role, particularly when it relates to occupiers in longer-term buildings, and quite often it's not right. So I think it's a difficult concept, I think, for some people to grasp. I mean, even, here you go, back in the day when I was a little article clerk, did 5-year articles, one of the things that we used to do was actually go and have to search the electoral roll. Used to be in Short Street in Southport. You'd go in there, you'd look for Chris Hines, you'd find him on your address, and you know that's his address, and then for the office, you'd go and serve him with something on behalf of a client. The body corporate role, in a sense, I suppose, isn't that much different. And I think there's a whole lot of misunderstandings from time to time about people in terms of what's actually in there and how it's used and how they can access it. And that's a little bit, I think, about today, you know. Yeah.
Absolutely. So we're going to cover that today. But first, Frank, a bit of trivia for you. I know you're a fan of trivia. Did you know that the word role comes from the old French or Middle English, and in fact from the Latin rotulus, and that means a roll, list, catalogue, schedule, record, a paper or parchment rolled up. So literally what would happen is that you would have all of the records, births, deaths, whatever, rolled up on a parchment. So, in old times you open up the parchment that way. That's the roll. That's where it comes from. And I suppose the other point about it being like that, it's that circular motion. And when you talk about circular motion, it keeps going, it keeps going, it keeps going. So the whole value of a roll, it keeps going, has to continually be updated. Otherwise, it's pointless. And no more is that the case than in the body corporate context. There you go. Fun fact.
Learn something new every day, and there's my thing for today. Ridiculous.
Before we get to the actual amendments, shall we bust a few role myths, Frank?
Would love to.
First and foremost, and the biggest thing I think about a body corporate role, there are no privacy laws which apply to a body corporate role, is there?
Not so far as it relates to fellow members or other interested parties of your body corporate, absolutely. And this would still hit our desks once a week, particularly in contested matters. So if we're acting for a lot owner and we're having an argument with the body corporate, or even if we're acting for a body corporate and we have an argument with a lot owner, and suddenly someone appears at the body corporate manager's office saying, I would like a list of what the role, the names and addresses and contact details of the people in this body corporate. The most common thing we get from body corporate managers in that sense is, no, they're covered by privacy, which is a complete fallacy.
No privacy. And that goes both ways, doesn't it? So if your name is on the roll and your fellow owner wants to, or not even fellow owner, there are a few other categories where that information can be obtained. You don't have any grounds to say, well, I demand my privacy and I don't want that information released. No, I'm sorry, but it's there. And the reason why it's there is, of course, again, if we want to be really fundamentalist about it, Frank, we go back to the name of the legislation: body, corporate, and community management. You're part of a community. And so once you're part of the community, the whole point of being part of that community is that you contribute, you're part of it, therefore your contact details are also there and part of it. And the role, Frank, isn't it? It's the primary way by which the body corporate communicates with its members.
Absolutely. And even back to, I mentioned before, you go search the electoral roll, you can have yourself removed from the electoral roll in a public sense, but you can't do that at body corporate law. There's no grounds for that. So once you are part of that community, you are part of the records, and you can't stop people accessing those records.
That's right. So there's also no ability for you to redact your details. And this used to come up back in the Commissioner's office, and I assume it still does quite a bit, where people would call in and say, oh, I've got some safety concerns about my details being on the roll. There's actually no ability to withhold, redact, and that's actually a really interesting policy question for government, I think, moving ahead, is as to how the government is going to treat that issue. And the most obvious example of that is somebody in a domestic violence situation, isn't it? Their details will be on the roll. And at the moment,
I wonder whether it might be, whether it might be at some stage just an equitable for an adjudicated order that someone's details be redacted, prevented, hidden somewhere. It's possible. I mean, in terms of, absolutely. There you go.
In a literal sense, though, a literal interpretation, there's no ability to redact that. And then it follows that if once you've obtained the details of the roll, Frank, what you do with that information after that, there really aren't that many restrictions on that either, are there?
Nope, because that's another common complaint. I can't believe, and literally I had an email 15 minutes ago on that same thing where we're acting for a resident manager. We've requisitioned a general meeting. We've had the chairperson email some owners directly to say, hey, what are you doing about this? And our client's email said, surely you can't do this. And I said, well, he can. That's access to the records. So, and I suppose, mate, if you're talking best practice, where we get to with that is that's what block notifying people as junk email addresses and those sorts of things are. That's the only way to really deal with it.
That's right. One of the common complaints, I think, Frank, that I'm familiar with is when somebody has searched the role, gotten details, gotten email details, which we'll get to in a minute. And David, I see your question there. Thank you. We'll get to that. And then they use that email address for lobbying on a vote in the body corporate. And the very, very common complaint is, well, surely that's not allowed. I'm afraid it is. My only comment, you probably know more about this than me, Frank, would be how you do that lobbying and
there's a fine art to that.
The language that you use in particular. But there's no restriction on that. And feasibly, there would be no restriction on if you had a right to access the role and you got those details and then you used it for marketing. That, I can't see how that would be restricted either.
No, I think probably the Privacy Act's more about the collection of information that comes into your possession in one way and you use it for another would be a very easy way to describe it. So it is an interesting one. And I do look at some of these bigger buildings from time to time and say, I don't understand why people don't market to the body corporate role more effectively than some of them do, but here you go. Yeah, there's a great untapped market.
The final myth, which would lead us very nicely into the amendments that we're going to be talking about, is that at the moment, it's not compulsory to include an email address. So if Frank and I are owners in a community title scheme and we don't want to give our email address for whatever reason, we don't have one or whatever the case may be, then that's that. We will get all of our notices by snail mail and it cannot be compelled.
And there's a newsletter on our website that we might post up on this later on that probably on the 1st of March will become academic to a degree, but not completely. It's and the question there, and it got litigated in the Commissioner's office quite a bit, was do email or are email address part of the body corporate role? And the essence of that was, if they're being used by the body corporate for the purposes of communication, then absolutely they are, even though they're not at the moment, in theory, required to be given. And they're still not going to be required under the new regime, but if those email addresses form part of the body corporate records, then they are available to other owners via a search.
That's right. That's right. So that, as I say, that's a really nice segue into the actual amendments. And there's not that many of them, but I think they're reasonably important to sort of cover. So the first one, as noted, an email address will still not be compulsory, which is an interesting approach by government, I think, Frank. It goes towards the idea that the body corporate can decide what it wants to do for itself for the benefit and the vote of all owners. But I find it really interesting that in this day and age, that would not be a little bit more mandatory. What do you think?
Yeah, I know this is part of the working groups that I suppose, again, we were both part of at the time, is compulsory, opt-in, opt-out, at all, the things that we're getting bounced around. And I will say, I'd say 99.9% of our clients have email addresses. I can, off the top of my head, name 2 people that we act for that don't use email, which is diabolical in the sense of that's how we communicate these days. So obviously it's still out there. But yeah, you would have, off the cuff, thought that maybe it would be a little bit more appropriate to make it compulsory, because if we are getting towards the stage of, I suppose, lessening the administrative burden, making it easier to get hold of people, getting more immediacy in the sense of getting people information when it happens. Sending things through post now, I think if you do them ordinary post, the guarantee that Australia Post gives you by ordinary mail is once you post it, it will be there within, I think, 5 business days. Yep. So, and in theory, I suppose, you can go back to the standard module where there's a notice of opposition. So, not that we're talking about this, but under the standard module, if a committee makes a decision and more than half of the owners object to that decision, I think it's within 7 days of it going out to them to check the dates, the decision can't be given effect. If we're doing that by post, it's almost impossible for that section to be ever used. So email would be totally appropriate for that sort of thing, but it's not.
That's right. So if there's an owner on the roll that does not have an email address, the committee and body corporate manager have to build in timeframes to allow for hard copy notices. And if they're
Should. This is the 21 days notice for general meetings, isn't it?
That's
21 days of sending, or is it 28 days to make sure that the first 7?
And there would be a very valid argument from an owner to say, well, I never nominated an email address, so I was entitled to receive a notice by post, and I was not given my statutory time frame in which, very valid argument. Anyway, so the amendment is an email address remains an opt-in thing, but if the email address is there, then it is taken as a given that the owner consents to service via that email address. So I think that's a really crucial distinction. So I don't have to give my email address, but if I do give my email address and Frank is my body corporate manager, then I have immediately consented to all of the service via that email address.
Levy
so what does that mean?
General meetings, minutes, the whole box and dice.
Yeah. So what does that mean? Well, it means a few things, doesn't it, Frank? It also particularly puts the onus firstly on the owner to give the right email address and to actually write it down legibly or key it in legibly. Then the onus goes back to the committee and the body corporate manager, doesn't it, to record that correctly?
It does. And I just sometimes people ring in and still give us gmail.com.au email addresses for us to contact them, and it's like you get the bounce back because you do it automatically and then suddenly no. So I think it is there's going to, I don't know who the poor bugger is that'll go onto the bus first in relation to a mistranscribed email address, but someone will, because they'll change the BCCM Form 8. I did have a look before and it's not live yet, which is okay, to actually create an email address column. But that still is going to be, I suppose, not automatic where I'm typing in the machine and into the body corporate records it goes. The form's completed, it gets probably emailed in to the body corporate manager, and someone then needs to transcribe that correctly.
Absolutely. And this is probably an opportune moment to address your question, David. So David, it says, can you advise the other lot owners and ask if they want to remove their personal email and phone numbers and just leave their address for service? Yeah, you can actually. So what Dave, and actually this is quite a valid, I'm loath to use the word tactic, but a method, particularly in schemes where, how do we put this, Frank, where many other owners would prefer that some other owners do not contact them for different things. It's quite appropriate for the committee via its body corporate manager to go to owners and say, maybe you want to just revise the details that you have given us on your role.
Or if you do give us all of these particulars, just be aware, and I suppose you'd come back to the first 5 minutes of this webinar, that you may be contacted on them by other members of your body looking to express their point of view. So if you want communication by that channel, leave your details there. If you don't, then please ask us to remove them.
Fair enough. We're going to get to some best practice about that towards the end of the webinar today, so we will circle back to that one. But the other main legislative change is to do with some timeframes about how the role is updated. So the first of those is that it's a reduction in time from 2 months to 1 month of the time frame in which to notify the body corporate of certain things. I think it's interesting to go through this list, Frank, of the circumstances, because I reckon a lot of people would not be aware of some of these things.
No, and I bet you a lot of people have it in their bylaws. And the bylaws are not the appropriate place to deal with statutory obligations like this.
Well, they would be invalid probably at that point. So here are the triggers for notifying the body corporate for the purposes of the role. And this now needs to be done within 1 month after any of this happens. So a person becomes the owner of a lot. Fair enough. A leasehold interest in the lot is created by lease for a term of 6 months or more. So that is probably one of the ones I suspect, Frank, a lot of people don't know. Basically, the instant that you have somebody who is an occupier for 6 months or more, details have to be put on the roll. That's the only reference to the term of a lease for an occupier under body corporate legislation. Really important one, though.
It is.
Yep. The next one, the owner of the lot engages a person to act for them in the letting of the leasing or leasing of the lot. Interesting. The engagement of a person to act for the owner of the lot for the letting or leasing of the lot, and it's terminated.
So we've got occupiers in, occupiers out, agents in, agents out.
Yep. The lot is and this one's an interesting one. The lot is the subject of a registered mortgage and the mortgagee enters into possession.
Yeah, and that is really, really interesting from a levy recovery perspective. Because we've seen situations where mortgagees have entered into possession by notifying under that and then decided when they don't want to deal with it anymore because there's no equity left in the lot, they withdraw that nomination. So in theory, then no one's in possession of the lot. It's a really interesting legal issue.
And then the final circumstance is where there's an interest in the lot, which is the subject of a registered mortgage, and the mortgagee enters into possession of the lot. So there you go. 6 instances in which there is an obligation to notify the body corporate for the purposes of the role. And that now needs to happen within 1 month. Here's another interesting bit of trivia. All of those obligations come with a penalty if it's not done. Right. It's one of the few parts of body corporate legislation that has a monetary penalty attached to it. And in this case, it's 20 penalty units. What's a penalty unit, Frank?
I didn't Google that, Chris, but I'll do that right now because it goes up by CPI every year, so it's this really random number. Penalty unit, Queensland.
But basically, for everyone watching, a penalty unit is
$133.45.
That's right. So that's the benchmark, and then in legislation there is a multiplier. So in this case, it's 20 times 130 odd. What's that? Nearly $3,000. Nearly $3,000. So there is the ability for a body corporate to seek a monetary penalty against an owner and various other parties concerned with the lot if they don't update the role. There you go. Who is going to do that, I hear you ask? Well, that's another issue, but that is actually a tool. It's a stick and a carrot thing, isn't it?
It is. It is, and it's really interesting, I suppose, when you get down to the nitty-gritty of these things and you look at the legislation in detail, I didn't know that was actually there. I suppose it hasn't come across my desk all that often, but then again, mate, I didn't know what alternative insurance was until you piped up at a North Queensland seminar probably 2.5 years ago and said, hey, do you know this thing's there? I said, no, I didn't. There you go.
And look where we've gotten to now. But that's I think really important for people to remember that. And then the other change that we need to talk about is that once the body corporate receives information to update the role, body corporate must update within 14 days, and that got reduced from 28 days.
Yeah, we sort of halved the time periods for both of those.
Yeah. A couple of other changes which strictly aren't about the role, but are very, very closely linked, Frank. Tell us about service to the secretary and body corporate manager.
Interesting. So this came up last week. We were talking about it, a decision called Whitsunday Waters. There's the Act can be quite prescriptive in the sense of how material is delivered. So probably the two examples, or the one before the most recent one, was voting papers. So there was massive argument way back when about voting papers. So voting papers, the Act says, must be delivered to the secretary by hand, post, or whatever it might be. And that was adjudicated at one stage to mean an intermediary can't interfere. So I can't give my voting paper to Chris and Chris can give it to the secretary. It doesn't work that way. I've got to actually make the effort to give it to the secretary. After that, in a sense, there was this decision called Whitsunday Waters, where it said that for a voting paper to be given to the secretary, it must be given to the secretary. And it didn't have it in brackets afterwards, not the body corporate manager. So if I gave my voting paper to the body corporate manager and the body corporate manager gave it to the secretary, that actually rendered it invalid. So we actually had, and I suppose, Chris, this is an example of how adjudication works. That was a really, really tight decision on a special resolution where there were 2 votes given direct to the body corporate manager, which effectively changed the outcome of the vote. So a special resolution, in effect, is 2/3 of people who voting in favour of it, along with a couple of other thresholds. But those 2 tipped it across the line. Without them, the resolution went down. We had a body corporate manager email both of us yesterday to say, hey, I know this previous decision, and here's one where they were given to the body corporate manager, and the adjudicator didn't disturb the decision. So what's all that about? And the adjudicator made a specific reference to say that it didn't change the outcome of the vote.
Yep.
So that really comes back to that high level thing. If it's going to make a difference to what's gone on, then absolutely there may be a different outcome than a strict legal interpretation of what the section says. And that's that ability of an adjudicator to make an order that's just and equitable in the circumstances. Depends on all of the things in front of them. So there's 2 factual scenarios which were, for want of a better phrase, identical. In one, the votes were prevented from being used, and the other, they were authorised. But to get to your point, Chris, I suppose, section 222 of the new module says that if you give your voting paper to the body corporate manager, it's deemed to be given to the secretary. So it's taken that element of risk away.
Which is common sense, but an important clarification nonetheless. One other quick change related to the role is that service by the body corporate to the owner or one of those other people that we talked about not so long ago can occur by, and the legislation refers to this as a file sharing website. And there are various examples of that. I think basically it's the legislation's attempt to clarify what a portal is, which is all well and good. Importantly, and I only realised this the other day, Frank, when I was rereading this section, needs to be prior agreement first with the owner. So if the owner has not agreed, then technically it can't be done. And so if it is being done without the owner's agreement, it shouldn't be, technically.
So the BCCM Form 8 that is produced on the 1st of March is going to be particularly interesting to see whether there's some sort of consent ticker box thing on that, isn't it?
Absolutely.
I was going to say, the other thing I think that probably is just worth discussing for all of 2 seconds is the position of the body corporate seal hasn't changed. So when this discussion paper came out, however many years ago, that is I suppose the basis for these new modules that are commencing in 2.5 weeks, there was a big question about the body corporate seal. Do we still need them? And the answer is yes. So there is still a hard copy seal that people are going to have to seal on body corporate documents. And in the absence of a resolution to the contrary to say the seal can be affixed by Frank Higginson, for example, which in theory would be legal, even though I'm not a lot owner, is that it's got to be two committee members signing it, one of which must be the chairperson or the secretary. That's the default position. So yeah, we still do have hard copy seals.
And if you want to know how to make a seal or how to get a seal, you just go to a stationer's outlet, get it done. It's as simple as that. There's no kind of like old-timey, waxy thing happening. You go and get a seal. Got a couple of questions there which we will answer, but I just want to get into the best practice stuff and a couple of things to sort of point out to people based upon everything that we have talked about today. So by all means, if you are really uncomfortable about providing your email address, opt out. But bear in mind that if you do that, you'll end up costing yourself ultimately, because if things have to be sent to you hard copy, that's a charge that the body corporate is going to incur. And that's a charge that you will ultimately meet through your levies. So by all means, do it, but just be aware that there is a cost related to that. The much easier way, if you are concerned about your privacy and about your email address, create a brand new email. And I've said this so many times, I'm sick of hearing myself say it, but it's a really easy one. Create an email address that is only for body corporate business. And that's it. Don't put down your personal email address. Don't put down your work email address if you can help it. Create an email address only for body corporate stuff. Put that on the roll. Not only does that give you a bit of breathing space, it creates a bit of distance, doesn't it, Frank? It depersonalizes.
It does, and I think it's even more important for committee members. So, and we are dead set starting to see more email addresses for committee members being ironsbodycorporate@gmail.com, which is the name of their building. So that they are breaking up personal and I suppose body corporate business into separate buckets.
Absolutely.
More of that is happening.
Another best practice tip, this one is more so for committees and body corporate managers, be proactive about the role. Don't sit back and wait. Take the opportunity to remind people to update details. People change address all the time. People change email addresses too. People change phone numbers. That happens a lot. And there's this whole process to go through for notifying people and so on. I'm sure the body corporate role ends up being way down on the list. But so don't wait for that to actually happen. Be proactive about it. If there's a notice going out to all owners anyway, why not put a little block in there? Have you changed your details lately? Please update the role and make it a positive thing. So rather than be threatening about it, if you don't, then this will happen, make it positive. That's how we're going to keep contacting you. That's how you'll find out about important business that is happening. It'll save a lot of time and money. I know it sounds like a bit of work. I reckon, I don't know what you think, Frank, but I reckon body corporate managers could actually relieve themselves of a lot of stress by doing that.
Agreed.
I don't know. And then finally, I think another thing for body corporate managers and committees, I think there's an onus, as Frank said before, keep monitoring the spam, keep monitoring bounce backs. Because if somebody's correctly given an address and there's been an error, then I reckon that enlivens the special reasons conditions under section 145(6) of the standard module. So under that section, a committee needs to consider if there are special reasons for reinstating a discount or waiving a penalty. I reckon a miskeyed email address would absolutely be one of those, Frank.
A full stop in the wrong spot, or a .co instead of a .com or something like that. You can just see it coming, and I suppose just don't let it be your body corporate to the extent you can avoid it. So if someone's not responding to not paying their levies, the first thing would be, and there was an adjudication on this a few years back, where there was an address that was wrong, and they were getting returned to sender, and an adjudicator speared a body corporate for recovery costs in the sense of you could have fixed all that by phoning the person and you had their number.
Yep.
So rather than just going through the machine and spending 6 months sending nasty letters and racking up costs, ring them and find out. So if people aren't paying, I think it's really important part of the process is to actually contact them. Make sure you do have the right details.
Yeah, absolutely. Couple of questions there, Patrick. Hi, Patrick. Your question is more about the conciliation than I think the address information. It's probably not a great idea for me to be talking about the conditions or circumstances of conciliation. All that I will say is that if an owner nominates an owner has to nominate an address for service, that's a no-brainer. Whatever they nominate has to be, I think it's an address in Australia, Frank, is that right?
An Australian postal address. I've actually brought this section up while I've had a look at it. Interestingly enough, there's no section there allowing personal service. So my two things that jumped straight out at me was an unapproved mailbox might not be an Australian postal address. I suppose that's a question for Australia Post. So if that's the case, then you're not actually complying with the legislation. Part B of that was actually going and giving them the notice personally. So as much as there's no scope, it would seem, under the BCCM Act for personal service of body corporate records, I think it would be very hard for someone to contest they didn't get it when you physically gave it to them and put an affidavit into that effect.
I think
would be my immediate take. You got it?
I think so too. Yeah. Wendy, thanks again for tuning in. Enforcing penalty units done through Commissioner's Office or legal proceedings. It's legal proceedings. Commissioner's Office doesn't enforce penalties. It's basically commencing a proceeding under the Justices Act. The body corporate can do that whenever, however. So, and that's probably a pretty good point for any penalty under body corporate legislation. None of that goes through Commissioner's Office. They don't do any enforcement. You can go crazy. Go nuts. Yeah. Well, maybe not go crazy, but
yeah. And for Rian, you can have overseas addresses. Part B of that is an Australian postal address or a residential or business address inside or outside Australia. So you can have overseas addresses because we obviously have plenty of overseas owners owning some of the 500-odd thousand strata title units in Queensland.
Yeah. Gosh, for a relatively what we thought was going to be a small topic, we're already over time, Frank. Jeez.
Every single week.
No, that's true. It always happens that way.
Maybe it was all the attempt at humour at the start that we didn't get right. I don't know.
Maybe. Look, I think the takeaway for everyone today is it's very easy to overlook the role and the changes to the role because it seems like boring admin stuff. But I can assure you, it is at the heart of so many problems which happen. So better to be proactive and on the ball about it at the start. Saves time, money, and a lot of hassle in the end. So with that, we'll wind it up. Now, we've got a couple more weeks until the new regulation modules. We'll be doing a last-minute overview primer the week immediately before. So if you're a bit stressed or a bit panicky about it all, it's all good. We will help you. We'll help you.
I think that's false and misleading advertising, Chris.
I was going to say we're going to help people chill out. But,
okay, yeah, that's fair enough.
But we'll give it a go anyway. Yeah. That won't be next week. That'll be the week after. Stay tuned for next week. Next week's topic just eludes me at the moment, but you will find out about it, I can guarantee. Please don't forget to like and share. Fire us a question or a comment on Facebook if you need to. Keep subscribing to our email updates too, because that's where we're going to advertise each month's bracket of webinar topics. With that, Frank, thank you.
Oh, thank you. And thank you everyone for tuning in as always.
Yeah, really appreciate it, everyone. Keep tuning in. We'll see you next week.
Bye. See you, everyone.